Dictation will start within 5 seconds. Start. One of the apparent and unavoidable consequences of reading the provisions of Section 11A of the Central Act into the State Act would be that it is bound to adversely affect the development scheme under the State Act and may even frustrate the same. Stop. It is a self-defeating argument that the government can always issue fresh declaration and the acquisition in all cases should lapse in terms of Section 11 of the Central Act. Stop. The argument also does not stand when tested on the touchstone of the principles test of unworkability, test of intention, and test of frustration of the object of the principal legislation. Stop. As per the scheme of the two acts, the conclusion has to be that they can be construed and applied harmoniously to achieve the object of the State Act, and it is not the requirement of the same that provisions of Section 11A of the Central Act should be read into the State Act. Stop. The obvious animus is that the provisions providing time frames, defaults, and consequences thereof, which are likely to have adverse effect on the development schemes, were intended to be excluded. Stop. Thus, it will be clear that the provisions relating to acquisition like passing of an award, payment of compensation, and the legal remedies available under the Central Act would have to be applied to the acquisitions under the State Act, but the bar contained in subsection 6 and 11A of the Central Act cannot be made an integral part of the State Act, as the State Act itself has provided specific time frames under its various provisions as well as consequences of default thereto. Stop. The scheme thus does not admit such incorporation. Stop. The BDA Act has already been held to be a valid law by this court, not repugnant to the Land Acquisition Act as they operate in their respective fields without any conflict. Stop. For the reasons stated in different decision as well as the detailed reasons given in the case of Girnar Traders, which reasoning would form part of this judgment, it is concluded that the BDA Act is a self-contained code. Stop. The language of Section 36 of the BDA Act clearly mandates legislation by incorporation, and as per the scheme of the two acts, effective and complete implementation of the state law is without any conflict possible. Stop.